Assalamu alaikum wa rahmatullahi wa barakatuh, and good day. We are reviewing the case of Dr. Krishnan and another, and Megat Noor Ishak, Megat Ibrahim and another appeal, 2018, 3 CLJ 427. This case is on the case of the torts of negligence, specifically medical negligence, and we are reviewing this case as a part of our syllabus for Laws 1340 under the instruction of Dr. Khadijah binti Muhammad Najid. This case review will be presented by me, Ayman Amani Isma binti Abdul Karim, and my partner, Nur Ain Fariha binti Haimah Nizan. We will start with the parties of the suit. At the High Court of Malaya, we have Megat Noor Ishak, Megat Ibrahim as the plaintiff, with Dr. Krishnan and others as the defendants, and the case citation being 2010, 10 CLJ 343. At the Court of Appeal, there are two appeals being made. The first is appeal number W02-2752-2010, and the appellants here are Dr. Krishnan as well as Dr. Muhammad Namazi, with the respondents being Megat Noor Ishak, Megat Ibrahim, as well as the Tun Hussein On National Eye Hospital. And the case citation here is 2015, 1 LNS 1476. And the second appeal is appeal number W02-2824-2010, with the appellant being the Tun Hussein On National Eye Hospital, and the respondents being Megat Noor Ishak, Megat Ibrahim, Dr. Krishnan, as well as Dr. Muhammad Namazi. The case citation here is still 2015, 1 LNS 1476. Having both appeals dismissed at the Court of Appeal, all three appellants appealed again at the Federal Court in Putrajaya. And with the two appeals again, with the first appeal, the appellants are Dr. Krishnan and Dr. Muhammad Namazi, and the respondents are Megat Noor Ishak, Megat Ibrahim, and the Tun Hussein On National Eye Hospital. And for the second appeal, the appellant is the Tun Hussein On National Eye Hospital, and the respondents are Megat Noor Ishak, Megat Ibrahim, Dr. Krishnan, and Dr. Muhammad Namazi. And the case citation here is 2018, 3 CLJ 427.
Now, I will explain the material facts of this case. The plaintiff's right eye had a giant retinal tear with detachment, for which the first defendant performed the first operation, a retinal detachment operation at the fourth defendant hospital. There were concerning issues including pain, watery eyes, limited vision, inexplicable external bruise, and tears of blood on the plaintiff's right eye after the first operation. However, during the immediate telephone call, the plaintiff consultation with the first defendant, as well as a scheduled checkup, the first defendant assured the plaintiff that there was no cause for concern. On the second appointment at the third defendant hospital, after the plaintiff suffered constant pain and pressure in his right eye, the first defendant recommended an urgent second operation after physical and visual examination due to a folded retina in his right eye. However, the plaintiff claimed that after receiving the analysis of a scan, which was prompted by the plaintiff's reluctance and request for verification, the first defendant admitted that his earlier findings were incorrect. Nearly 2 months after the first operation, the first defendant again insisted that the plaintiff's retina had folded or partially detached and refused to perform another scan. The first defendant performed the second operation on the plaintiff's right eye, with the second defendant being the anesthetic, despite the plaintiff's concern on his safety regarding the operation. According to the plaintiff, it was not examined nor interviewed regarding his medical history by the second defendant, and the anesthesia was administered by a nurse without supervision by the second defendant. The plaintiff was later told that the operation resulted in suprachoroidal hemorrhage (SCH) in his right eye as a result of the plaintiff gaining consciousness during the end of the operation and had barked while the first defendant was strengthening the retina with laser. However, the first defendant told the plaintiff that he would not lose his eyesight if the retina remained intact after the bleeding had stopped, and did not mention the likelihood of the plaintiff losing his eyesight in his right eye. The plaintiff was recommended to stay in the hospital, during which he was given instructions to reduce the bleeding in his right eye. During the hospital stay, the plaintiff experienced severe pain, constant bleeding, and a total loss of vision in his right eye, on top of severe nervous shock, mental agony, extreme anxiety, and distress over the condition of his right eye. The plaintiff only began to realize the severity of his condition after he was discharged from a letter written by Dr. Paul Singh, to whom he was referred for a second opinion when he discovered that the lens in his right eye was removed during the second operation without his consent or knowledge. The plaintiff was also told that his retina was badly uprooted with a lot of internal blood clotting and that the care recommended by the first defendant was useless given his condition. Following this, the plaintiff consulted again with the first defendant and was given a contradicting statement, which is that his right eye was still bleeding. The plaintiff was referred to Dr. Seshan Lim of the Lions Eye Centre, who concluded that the plaintiff's right eye was beyond saying. For the first time, the plaintiff was enlightened to the fact that his right eye had been blind and beyond saving since the second operation. A medical report by the first defendant a month later confirmed that as a result of the retinal detachment, the plaintiff's right eye is irrevocably blind. Still hopeful, the plaintiff went through another surgery by Dr. Ong Ziz Kwan at the Singapore National Eye Centre, but it was unsuccessful. That is all for the material facts. Now, I will leave it to Ahmad to explain on the findings from the High Court, Court of Appeal and Federal Court.
Now let's take a look at the findings from the High Court. After a full trial, it was found that all three defendants were liable. The first and second defendants were negligent in failing to warn the plaintiff of the danger of bucking and blindness, as well as being negligent in their care and management of the plaintiff. The third hospital was also found vicariously liable for the negligence of the first and second defendants. The patient was awarded 200,000 ringgit as general damages and an unprecedented sum of 1 million ringgit as aggravated damages. At the Court of Appeal, the appellants appealed against the decision of the High Court made on the 1st of September 2010. And the Court of Appeal dismissed the appeals by both the doctors and the hospital and affirmed the decision and the award of the High Court. Therefore, the two doctors are found medically negligent and are thus liable, while the hospital was also found vicariously liable. And at the Federal Court unanimously dismissed the doctors and the hospital's appeals and affirmed the High Court's award of damages to the patient. And we will now examine the Federal Court's grounds of judgment. The counsels for the appellants are Kanaga and Vinod Ramasamy and Ms. Kanaga from Suresh and Company Law Firm. The counsels for the first respondents are Leong Wai Hong and Claudia Chia and Wong Juen Wei from Scrine and Company Law Firm. The counsels for the second and third respondents are P.S. Ranjan, M.S. Dhillon and K.B. Karthi and Rama Tarini and Miss P.S. from Ranjan and Company Law Firm.
The judges hearing the case of Dr. Hari Krishnan at the Federal Court is firstly, Chief Justice Muhammad Raoul Sharif, secondly, Chief Justice of the High Court Ahmad Maroof, thirdly, Federal Court Judge Zainun Ali, and lastly, Federal Court Judge Ramli Ali. The area of law of this case is medical negligence and civil proceedings. So in this Federal Court case of Dr. Hari Krishnan, we have identified 5 legal issues to be discussed. Firstly, whether the trial judge had given a non-speaking judgment. Secondly, whether it is the Bolam test or the test in the Australian case of Rogers and Whittaker which should be applied to the standard of care in medical negligence following after decision of the Federal Court in Fu Fiona and Dr. Su Fuk Moon and another conflicting decisions of the Court of Appeal, the High Court in Malaysia, and the legislative changes in Australia, including the reintroduction thereof a modified Bolam test. Thirdly, whether Dr. Hari Krishnan and Dr. Namazi had breached their duty of care to warn the risk of the operation and to provide proper treatment to the respondent. Fourthly, whether aggravating factors should be compensated for as general damages, therefore rendering a separate award of aggravated damages unnecessary, as decided by the English Court of Appeal in Richardson and Hoey and explained in the Michael Jones Medical Negligence 4th edition 2008. And lastly, whether the doctors are qualified professionals in a private hospital and working as independent contractors by virtue of a contract between the private hospital and the doctors. can the private hospital be held vicariously liable for the sole negligence of the doctors?
Now let's take a look at the ratio decidendi. The first ratio decidendi is on the topic of non-speaking judgments and when to order a retrial. So a non-speaking judgment is when the judge fails to give reasoned judgments for the conclusions they make and give no explanation of the findings. The Federal Court gave a guidance for the lower courts facing the same issue in the future. The Federal Court agreed that the trial judge gave a non-speaking judgment and they disapproved of this non-speaking judgment. However, the Federal Court said that it doesn't necessarily mean that the court must order a retrial. This is because the party seeking retrial has the burden of proving that there was injustice carried out or a substantial fault before a retrial is granted. The alleged negligence here happened in 1999 and the trial was between 2007 and 2010 with 23 days of trials and 10 witnesses. And a retrial would prejudice all parties as well as it will be against the ideal interest of justice. And the Federal Court cautioned that a retrial must not be easily ordered. This is because the appellate courts have a duty to make their own findings of fact based on the evidence available in the records of appeal.
Moving on to the second ratio decidendi, we have identified this ratio decidendi from paragraph 61 to 64 in the case law. So the second ratio decidendi to answer the second legal issue is the Federal Court judges answered the issue by stating that the test in Rogers and Whittaker, which was followed in Fofiona, is restricted only to the duty to advise of risks associated with any proposed treatment under the element of standard of care in medical negligence. Hence, the task in Rogers and Whittaker does not extend to diagnosis and treatment. This is because the Bolam test still applies but subjected it to the condition that the expert opinion must be capable of withstanding logical analysis by the House of Lords in Bolito if it is concerned with the standard of care for diagnosis and treatment. On the other hand, the Bolito test is an extension from the Bolam test for the court to analyse the logic and reasonableness of the conflicting medical opinion advanced by the defence before accepting the same that occurs when the Bolam test applied. The question now is uncertain on which legal test is correct to be applied in Malaysia. So the Federal Court then cited the case of Zulhasnimar, Hassan Basri and another, and Dr. Kupu Velumani, P and others, of the distinction to be made between diagnosis and treatment in medicine and the duty to advise the patient of the risk. The former is not within the expertise of the courts and thus cannot be resolved by the courts, whereas the latter is an issue of the fact that the courts are able to determine. As a result, the Bolam test as qualified in Bolito remains in effect to the issue of the standard of care in medical diagnosis and treatment, whereas the Rogers test as propounded in Fofiona applies to the duty to warn of potential risks associated with a procedure. It is essential to know the Bolito qualification attached to the Bolam test. While doctors may know best, the expert opinion presented in court must be capable of withstanding logical scrutiny. If the court decides that it does not meet the criterion, it may rule that the expert opinion is not reasonable or responsible and disregard it. So that is exactly what the Federal Court did in the I appeal. During the trial, the patient called an expert witness to testify that the doctors had failed to meet a reasonable standard of care. The doctors also called their own expert witness to testify that they did not violate the standard. The Federal Court examined the opposing expert evidence and concluded that the doctors were negligent in diagnosis and treatment, as well as failing to warn the patient of the risk. This was due in part to inconsistencies in the expert witness testimony of the doctors. Therefore, the court may consider expert evidence on what the acceptable medical practice is, but ultimately it is for the courts to adjudicate on the appropriate standard of care based on the expert evidence. So what we can conclude from this second ratio decidendi, the decision of the Federal Court in this case is that it is important for the court to put the parameter of differences of standard of care to be used to find the correct legal test to judge the standard of care of the medical personnel. Then only the court can adjudicate based on the expert evidence of logical analysis. Now, I will pass the turn to Ahmad to explain on the third ratio decidendi.
The third ratio decidendi is talking about the duty to explain the risk and provide proper treatment. We will be dividing this into three sub-issues. Firstly, did the doctors breach their duty to explain the risk of bucking and blindness? The federal court here says that the duty to explain the risk is specific in nature, and the consent form signed by the plaintiff only contained general precautions that the operation was risky. Neither doctors warned the plaintiff of the risk of bucking nor blindness at any material time. And it can be assumed that any reasonable person would find this risk significant, but the plaintiff in particular has actually requested scans and questioned the necessity of this operation. So by not warning the plaintiff, the doctors had breached their duty to explain the risk and were negligent, because they deprived the plaintiff of the opportunity to make an informed choice to continue or to forego this operation. Moving on to the second sub-issue on the diagnosis, Dr. Hari failed to establish that his diagnosis that the plaintiff required such treatment was according to an accepted, proper and reasonable practice, as well as that it reached the standard of a responsible body of skilled medical practitioners in this specific expertise. And on the topic of providing proper treatment, was Dr. Hari adopting a procedure that was adopted by a responsible body of medical practitioners? The federal court said that experts from both parties agreed that the second operation was only necessary in the case of a retinal detachment. However, contemporaneous documents and witness testimonies failed to prove the existence of a retinal detachment in the case of the plaintiff. The federal court stated that Dr. Hari was negligent because he subjected the plaintiff to a needless operation that led to the plaintiff's loss of eyesight, and he had also failed to prove that this procedure used to treat SCH was accepted by a responsible body of medical practitioners. So here the Bolam test was not satisfied, and Dr. Hari was found negligent in his choice of procedure in treating the plaintiff. So did Dr. Namazi breach his duty in his treatment of the plaintiff? In applying the Bolam test, the federal court found that Dr. Namazi did not produce any evidence proving his failure to ensure plaintiff did not buck was supported by a body of responsible medical opinion. And it was found that the plaintiff bucked because he was not anesthetized properly. Bucking could be avoided and controlled by additional drug, and the top-up dose administered was clearly mistimed. Thus, the federal court found that Dr. Namazi was negligent in failing to keep the plaintiff anesthetized completely during the second operation, and so the doctor's appeal on liability was dismissed. And in applying the relevant tests established earlier in the second ratio Decidendi, which is from the case of Zul Hasnima Hassan Basri and another, and Dr. Kupu Velumani, P. and others, both Dr. Hari and Dr. Namazi were found negligent by the federal court in their advice of risks, diagnosis, and the treatment of the plaintiff.
We have identified the fourth ratio Decidendi from paragraph 99 of the case law. For the fourth ratio Decidendi, to answer the fourth legal issue is, the federal court referred to the case of Muhammad Rizwan Abdul Razak and Asmah Haji Muhammad Noor, decided that aggravated damages could and had been awarded as a separate head of damage in tort. Moreover, aggravated damages are frequently awarded in defamation cases for injury to a person's reputation. Hence, there was no reason to exclude these kind of damages from medical negligence cases, which involve the real injury to a person's body. In the circumstances, the second question was answered in the negative. As such, doctor's appeal on quantum was dismissed. So the federal court affirmed the decision of the High Court to grant the patient 200,000 ringgit as general damages and unprecedented sum of 1 million ringgit as aggravated damages. So that's all from me. Now I'll pass the turn to Ahmad to explain the last ratio decidendi in this case.
The fifth and final ratio decidendi that we've identified will answer the question of, can a hospital delegate its duty of care? In this case, the federal court distinguishes between vicarious liability and delegating duty. Firstly, we will look at the vicarious liability. The hospital asked the federal court whether doctors are qualified professionals in a private hospital and working as independent contractors by virtue of a contract between the private hospital and the doctors. Can the private hospital be held vicariously liable for the sole negligence of the doctors? The federal court says no. The federal court held that where the doctor is ascertained to be a truly independent contractor in the circumstances, the private hospital could not be held vicariously liable for the sole negligence of that doctor. So how do you identify what is the true relationship between a private hospital and doctor? The federal court states that it must be determined from the relevant contractual terms as well as the factual circumstances of the case. In this specific case, the federal court found that Dr. Hari's diagnosis of condition, advised to undergo second operation, and his conduct of it were done in the course of Dr. Hari's private practice. There is no evidence that the hospital controlled Dr. Hari's advice or the conduct of the second operation. Both are attributable to his own recognizably independent business. While the court recognizes the change in location to the hospital for follow-up appointments, as well as the use of hospital's facilities in conducting the second operation, it does not change the independent nature of Dr. Hari's business. At the same time, the fee structure is also not indicative of a contract between employers and employees. This is because Dr. Hari charges his own fee to his patients, and Dr. Hari was required to pay fees for using the hospital's facilities and services, as well as the collection of patients' fees and remittance to Dr. Hari by the hospital was only administrative in nature. In short, the federal court found that Dr. Hari's advice and conduct of the second operation is not part of the hospital's business activity and is not done on behalf of the hospital. So, Dr. Hari here was acting in the capacity of an independent contractor and not an employee of the hospital. So, no vicarious liability could be imposed for Dr. Hari's negligence. Moving on to Dr. Namazi, Dr. Namazi was a visiting consultant to the hospital, requested to provide his services by the medical director on a temporary basis. The federal court found that the hospital management did not interfere with Dr. Namazi's work, and Dr. Namazi was not paid by the hospital for the services. Instead, the fees are paid by the patient to Dr. Namazi through the hospital, and the hospital's role in collecting fees are purely for administrative convenience. These factors were characteristic of a contract for services with independent contractors rather than a relationship of employment. So the hospital is not vicariously liable for the negligence of Dr. Namazi in the second operation. However, the federal court here stated that where a hospital is held to owe a non-delegable duty to patient to ensure reasonable care is taken in his treatment, then the hospital may be liable to the patient if this duty is breached, regardless to whom this performance is delegated to. To answer this question, the federal court applied the case of Woodland and Essex County Council, and the federal court found that the plaintiff was a patient admitted into the hospital for the second operation, and the plaintiff here is a vulnerable person dependent on the hospital for protection. So to the plaintiff, there was no doubt that when the plaintiff was admitted for the purposes of the second operation, the plaintiff was placed in the hospital's custody or care. The plaintiff also had no choice of anesthetist, and it was found that instead it is the hospital that had requested Dr. Namazi to provide his anesthetic services, and it was also the hospital who delegated the responsibility to Dr. Namazi to administer doses properly so the plaintiff would stay anesthetized throughout the second operation. So the federal court found that an integral part of the positive duty assumed by the hospital to the plaintiff was to ensure that care was taken in the provision of anesthetic services. From the evidences, the federal court found that Dr. Namazi had mistimed the top-up dose, and Dr. Namazi also had caused the plaintiff to regain consciousness and buck. Thus, Dr. Namazi was negligent in the performance of the duty delegated by the hospital to him. So when applying the principles in the Woodland case, the federal court found that the hospital owed a non-delegable duty to the plaintiff to ensure that reasonable care was taken in the anesthetic services provided. Thus, the hospital is liable for the breach of duty, and the hospital's appeal was dismissed. The federal court also touched on the policy of non-delegable duty. They noted that the differences on the law of vicarious liability and non-delegable duty is still an ongoing development. They noted that in the case of Woodland, the court added a proviso, which said, proceed with caution, incrementally by analogy with existing categories and consistently with some underlying principles. The federal court here noted that a broad rule on the liability of private hospitals in medical negligence cases on the basis of policy alone would risk overgeneralizing the nuances of modern business relationships and result in an in-principled approach to liability.
As we have discussed the legal issues and also the ratio decidendi, this is the list of cases referred and followed by the federal court. There is no case law that was distinguished by the federal court in this case. And this is the list of legislations and other sources referred by the federal court. And this case law is reported by Suhaina Wahiduddin.
So here we are going to present our analysis of this case. Firstly, we note that this case clearly strengthens the differences between the duty to warn, the duty to diagnose, and the duty to provide proper treatment. While the establishment of these different duties has been established in the case of Zul Haslima Hassan Basri and Dr. Kubu Velumani, this case reiterates the importance of identifying them as separate duties under the case of medical negligence. And the reason is because different standards are used to measure if the duty has been breached. So for the standard of duty of diagnoses and treatments, the standard here will be compared to the standard of other competent medical professionals. So medical practitioners will be called to the stand as expert witnesses. However, in the case of standard of duty to warn, this is decided by the court according to the factual circumstances of the case. The second thing that we note is that this case established the imposition of non-delegable duty in Malaysia. This is because this case is actually the first time a non-delegable duty has ever been imposed in Malaysia. And we believe that the establishment of this duty would lead to hospitals taking greater care in making sure that they protect the safety of their patients through the services they provide, even if the performance itself is done by someone not directly under their employment. And we are of the opinion that this development in law is necessary because this will protect the interests of patients in the circumstances when they are vulnerable to the decisions made by the hospital of which they have no control over. Thirdly, we note that this case sets a higher standard for aggravated damages. This is because the award of 1 million ringgit is the highest ever awarded for aggravated damages. So this will then become a new benchmark for claims against professionals to be noted by their counsels that depending on the circumstances, awards of aggravated damages can far exceed the award of general damages. However, we believe that the caution must be exercised by the courts. Judges must take extra care not to allow simply any case to claim for such high aggravated damages. In this case, the breach as well as the consequences are severe enough to warrant such a claim, but this will not likely be the norm. In conclusion, this case proves that the development of torts under medical negligence is still underway. And this development and change depends on the development and changes in ethics and social awareness of the society, advances in medicine, as well as development in law. And this dynamic and ever-developing nature of medical negligence is actually very crucial to ensure that those vulnerable in their hour of need can feel safe in their search for treatment, being full aware that they are fully protected under the law, no matter the advancement either in society or in science. And that concludes our review of the case of Megat Noor Ishak, Megat Ibrahim, and Dr. Krishnan. We hope that this case review has been enlightening and gives you further insight into the details and significance of this case onto the Malaysian law. Thank you so much for watching. Wabillahi tawfiq wal hidayah. Wassalamu alaikum wa rahmatullahi wa barakatuh.